Just to put the record straight, Your Honor, when I said they are allowed, I was referring to leading questions, Your Honor, because the journal dated August 12, 2019 would show that I was indeed asking a leading question before Attorney Kapunan objected, Your Honor. So if we take a look at it, with all due respect, the objection was even improper at that time, Your Honor.
Thank you, Counsel.
I'd like to manifest, though, that, again, the statement of counsel is misleading because it was very clear. It was very clear, and the transcripts will show that the immediate phrase which led to my remark was not about leading, it was about misleading, Your Honor.
For the last time, and then we proceed with cross. It's already 11. Attorney Kapunan, leading, misleading questions are not allowed on cross. Ms. Ferrer, Attorney Ferrer, they are allowed.
Enzorecto, kalaban ang katiwalian at kasinungalingan, kakampi sa katotohanan at kabutihan.
Tigo sa ilalim ng nauna niyong panunumpa po. Kung saan nanumpa kayo magsasabi ng katotohanan at pawang katotohanan lamang. Naunawaan po niyan?
Yes po, Your Honor.
We may proceed now with cross. Attorney Christine, you ready?
Your Honor, if I may be recognized.
Yes, Attorney May.
Your Honor, before the defense counsel proceeds with their cross-examination, the prosecution respectfully moves that the defense be directed to conduct its cross-examination in a non-leading question form, Your Honor. Yesterday, Your Honor, this honorable court declared Mr. Artonio a hostile witness pursuant to Rule 132, Section 13 of the Rules of Court. And in so ruling, effectively, this honorable court also declared that the interest of this witness is aligned with the respondent. Now, Your Honor, the permission to conduct the permission to propound leading questions on cross-examination under Rule 132, Section 10A of the Rules of Court rests solely. Interest of the witness to be cross-examined is hostile or is adverse to the cross-examiner, making it difficult for the cross-examiner to put into the mouth of the witness words that he expects to be elicited. Now, that presumption, Your Honor, has already been overcome by the declaration of this honorable court. So what we expect, Your Honor, is merely cross-examination in form but not in substance. Because in substance, Your Honor, the cross-examination would effectively be like the respondent herself cross-examining, the respondent cross-examining or direct examining, conducting a direct examination of her very own Assistant Chief of Staff. Last Monday, Your Honor, we witnessed how the defense, under the guise of cross-examination, supplying testimonies to the witness, Ms. Gina Acosta, and merely expecting her to supply yes to each and every question, Your Honor. And that is the very evil sought to be prevented by the rule against leading questions on direct examination. Your Honor, I understand before I'm lectured on the contents of the rules of court, I'm very much aware of what the rules of court provide. But I'm also very much aware, Your Honor, that under the rules of this honorable court, the rules of court is merely suppletory in application. And in fact, the presiding officer is granted leeway to rule on every matter of evidence.
Comment, Attorney Christine.
Yes, Your Honor. Rule 132 of the Rules of Court does not convert a hostile witness as our own witness, Your Honor. So, therefore, we are not obliged to ask direct examination questions, Your Honor. Thank you.
If I may, Your Honor.
Short reply, and in so replying, Attorney May, kindly cite a legal basis outside of the Rules of Court, since you said it's not in the Rules of Court.
Your Honor, I'm citing the very own rules of this honorable court, saying that the rules of court is merely suppletory in application. And at the end of the day, it will be the presiding officer who will be deciding on matters of evidence. And early in the proceedings, Your Honor, if I remember correctly, two senator judges encouraged this honorable court to look beyond the wordings of the law and consider the intent for its application.
That it, Attorney May?
Yes, Your Honor.
Chair will make a ruling. Rules of court, although it has merely supplementary application to these rules, nevertheless do apply. And the rules of court state specifically that leading questions may be asked on cross-examination without any exception nor any limitation. And as held in the Bolos case, there is no need to interpret the rules in case where there is no doubt, and the rule is quite specifically clear. Number two, we already have a precedent, at least with respect to the previous witness declared as a hostile witness in the person of Gina Acosta, where the court allowed counsel for the respondent to ask leading questions. You shall be accorded the same privilege, Attorney May, on the part of the prosecution, should the respondent rather present a hostile witness during the presentation of their evidence in chief. The court shall apply the rule equally. So ordered.
Thank you, Your Honor.
You may proceed, Attorney Attorney Christine.
Yes, Your Honor.
When you're ready.
Yes, Your Honor. Before I start with my cross-examination, just to put the record straight, Your Honor, when I said they are allowed, I was referring to leading questions, Your Honor, because the journal dated August 12, 2019 would show that I was indeed asking a leading question before Attorney Kapunan objected, Your Honor. So if we take a look at it, with all due respect, the objection was even improper at that time, Your Honor. So, but I want that issue to be closed.
That was similarly pointed out by the presiding officer, counsel.
Thank you, Your Honor.
Sorry, Your Honor. Before I proceed, may my colleague be recognized, Your Honor? Attorney
Of
Kapunan.
course. Attorney Lorna.
Your Honor, please, first of all, I'd like to commend the presiding justice. Very clear. The ruling on sub judice is very clear, and we will take it with strict compliance, Your Honor.
Thank you, counsel.
I'd like to manifest, though, that, again, the statement of counsel is misleading because it was very clear. It was very clear, and the transcripts will show that the immediate phrase which led to my remark was not about leading, it was about misleading, Your Honor. If I heard it, if the whole legal profession heard it, if this courtroom heard it, if the outside audience heard it, then it must be, it is what it is. She had said misleading is allowed, and I responded to that, and I'd like that to be on record, Your Honor. Let us not mislead again this honorable court. Thank you.
Your Honor,
The chair already made a ruling earlier regarding this matter brought about by the lead counsel. In lieu of that, the chair will simply furnish the parties with a copy of the TSN, wherein, I will quote again for the record, for the last time, and then we proceed with cross. It's already 11. Attorney Kapunan, leading, misleading questions are not allowed on cross. Attorney Ferrer, they are allowed. This is what the transcript says, and it has no reference to Attorney Ferrer stating specifically that misleading questions are allowed. And perhaps the confusion arose with respect to the TSN, again, not being able to capture the perhaps overlapping statements made by both counsels, and we should leave it at that already, counsels, and move on.
thank you, Your Honor.
So, when you're ready, no more manifestations, Attorney Christine?
None, Your Honor. We will
Proceed
just,
to cross.
Yes, proceed to cross.
Attorney May, you shall be the counsel for the prosecution.
Yes, Your Honor.
Okay, you may proceed, ma'am, when you're ready.
Good morning, Mr. Ortonio.
Good morning, Mama Imbuntag.
Earlier, you said or you confirmed that no PFP or the no PFP was attached to the August 2022 letter request of the OVP to the DBM. Do you remember that?
Yes, ma'am. That's correct, ma'am.
Okay. And the reason for this was because at that time, it is not being required by the joint circular to attach the PFP to that letter.
Based on my understanding, ma'am, attaching the PFP is not required to the letter request, ma'am.
Thank you.
Bunyog, bunyog, halikan na kasama ka. Bunyog, kapag buklod ay may pag-asa. Luzon, Visayas, Mindanao, isa ang pananaw. Sa bagong Pilipinas ang bunyog isisigaw.